say, due to the inherent dangers in flying or not flying warning flags. They talk specifically about what they found was a danger. That's the constantly changing surf and other naturally occurring things along the coast. Not having anything to do with flags specifically, they put it where it's logical in the statutes.
Okay, but to follow up on Judge Stevenson's question, the irony of how they then created this exemption of liability, whether or not the flags are flown. In other words, they say at the beginning of the statute, we are requiring statewide this uniform system. Agencies like the city and the county, you shall do this. But if you don't do it, no harm, no foul to you. There's a certain, maybe that's the legislature's problem as far as the plaintiff's argument goes and not our own. But clearly you would agree with me that the statute now has no teeth.
Well, I agree that the statute specifically addresses the liability for death or injury due to those things that they recognize were commonly occurring. And they put it in the place where, as counsel said, it was logical in that it was beach safety was of interest to the legislature. And yes, they abrogated the laws that were set out by Vero. And because I think the legislature recognized that there's not a whole lot a government can do about those things that are naturally occurring in the ocean.
Let me phrase my question another way. What's the legislature's recourse if your city chooses not to put up these warning flags in compliance with the statute?
Well, what the legislature has said is if you do fly flags, they must be the flags that are approved.
You misunderstood my question or didn't answer it clearly. If you don't fly the flags in the city of Vero Beach, what can the legislature do to your city as a penalty?
Really nothing. As far as
And doesn't that defeat the very purpose that the legislature is attempting to accomplish?
No, I think the legislature there was, first of all, they were trying to make uniform the flags throughout the state. Plus, they were recognized, probably because of the road case, since they didn't address it directly, we have to presume, I suppose, that they were addressing the fact that, well, is this quite fair that a local government should be responsible for something they really don't have control over, in that these things are happening in the ocean that the city can't control other than, yes, make a warning through the flag system. But they recognize that sometimes these things are handled by humans, and the fact that the flags get flown or not is something that they can't control. They can create the system and urge the local governments to use the system.
Well, maybe a better solution that the legislature might have had, other than taking away the liability, would simply be imposing some kind of fine system, something to give this thing some teeth, right?
They certainly could have done that, but obviously they chose not to.
Would it be better if it would have been able to save the life of this young man, but I can understand from a sovereign immunity standpoint, if that's the legislature's policy choice, that's their choice.
And I think what happened was they did abrogate the sovereign immunity waiver for this situation, although in this particular case we were not really arguing the sovereign immunity issue. We were arguing strictly the issue of the statute says there's no liability, and therefore we don't even get to really the sovereign immunity issue, whether or not it was waived. Therefore, there was no duty analysis that had to be taken by the court.
Were the complaint allegations in this case clear that the city of Vero Beach had control over the area where this tragic drowning occurred?
We don't believe it was clear in the complaint. There were facts, obviously, that weren't stated in the complaint. It talked about the incident occurring in an unguarded area of the beach, and in fact, the beach controlled by the city is a guarded beach. So there is an issue that would come back to haunt the appellants that they weren't even at the actual guarded beach that was operated by the city.
All right, thank you.
Thank you.
Right, I'll give you an extra minute.
Excuse me?
I'll give you an extra minute.
Thank you, Judge. Just to address Judge Gerber, your question to Ms. Vargas, you mentioned the Owens case and this subsequent statute that was passed that changed the standard of proof required in a slip and fall case. In that particular statute, I believe the title, I don't have it in front of me, but I believe the title of that particular statute is Limitation of Liability to Corporations. other statutes that are cited by the opposing side, each statute that they cite clearly states that it's a limitation of liability. And I think the most analogous statute to this particular situation is what Ms. Vargas stated was the 3166145 pertaining to school bus, the seatbelts, the requirements. And what the legislature said, look, we want seatbelts on school buses. But if you don't use the seatbelts correctly, or if you don't use them somehow properly, then we're not imposing a duty. You're not going to be held responsible. You're not going to incur liability because of that. Because we're requiring you to do something, we're also going to give you immunity for that particular activity. That's exactly what the situation is here in this particular statute. If we look at the statute itself, the whole statute talks about nothing but warning flags. If we look at the first two paragraphs, it talks about a beach safety program. It talks about the flying of warning flags. It's only until we get to subsection 6 does it mention anything about liability. In the Senate analysis, they don't have that comma that's right after where it talks about the limitation of liability and then goes into whether or not the warning flags are displayed. I submit that what the intent of the legislature was in this particular statute, given its placement, given the language of the statute as a whole, given the title of the statute and where the statute appears, is to give a limitation of liability to the government for the flying of warning flags. Even in the Senate staff analysis, which was all part of the record in the trial court that was looked at, there's not one mention of the Vero case. Not one mention that Supreme Court precedent would be overturned by this particular statute. On the economic impact to the private sector as well as to the government sector, not one mention that these Supreme Court precedents would be overturned. It wasn't contemplated. It wasn't meant. And it's obvious, I believe, and I submit, by the result of the placement of this particular statute.
Thank you. Thank you both.